breaking news. The Chief Justice of India is making strong observations during the hearing on pleas challenging the validity of electoral bonds just ahead of elections. Now, CJI has questioned the selective anonymity of donors. Selective because CJI has pointed out that while probe agencies can get details from SBI on the electoral bonds, another party cannot know the source of funding of some other party, and nor can the general public. So the CJI questions a selective anonymity, a big observation. To share more on this, I will be joined by my colleague Harish on the phone line. Harish, appreciate you joining us now. Can you shed some more light onto what were the exact verbal remarks from the CJI during this hearing?
Yes, very big observations coming in from the Chief Justice asking regarding electoral bonds. Why? We are not saying there is a complete anonymity, but there is selective anonymity, and that is dangerous. He said that we are not saying it's a complete anonymity. We say selective because if investigating agencies want, they can get details from the State Bank of India, but a party cannot know source of funding of other party. Also, common man also doesn't get info. The problem with the scheme is that it provides selective anonymity and not general. It is not the SBI or the law enforcement agencies. Justice Sanjeev Khanna, in fact, went on to add, the problem is that the opposition parties do not know who is making the contributions to the ruling party, but the ruling party, though, through law enforcement agencies, will know who is contributing to them, and that is where the level playing field is getting disturbed. Person who is in power can have access. This is a gray area, and they say this is how cases are registered against opposition. The Supreme Court also said in another significant remark that if this scheme is struck down by us, no one is stopping or precluding the government from coming out with a more transparent scheme with a level playing field, less opacity and more transparency. The problem with the scheme is that it provides selective anonymity and not general. Remember, even during yesterday's hearing, Chief Justice told Election Commission's Council that its 2019 interim order, which required all political parties receiving funds through electoral bonds to disclose all details to the Election Commission in a sealed cover, and that is a continuing order. This was when Election Commission informed that Supreme Court that they only have the sealed cover that was submitted in 2019. So Supreme Court had yesterday also made a very significant observation that all parties should give details to the Election Commission in a sealed cover, not just 2019, also for later elections. And also the centre staunchly defended the electoral bonds. Appearing for the centre, Solicitor General Tushar Mehta said now system is very transparent, curbs use of black money in elections. Bonds brought in transparency and accountability in electoral funding. Earlier, donations were made in cash and unaccounted money made its way to the poll funding. But now bonds are KYC compliant, and since bonds are issued only by authorized banks and payments are through check, drafts and direct debit, there is an audit trail. So to say there is no transparency, it does not hold any water. Bonds were a pioneer step initiated to tackle black money and bring transparency and accountability in electoral. But the biggest takeaway, as you rightly said, is that Chief Justice questioned why there is a selective anonymity and no level playing field as far as the electoral bonds are concerned. Back to you.
Absolutely, Harish. Thank you so much. Appreciate you joining us live on the broadcast, breaking down these very key oral remarks coming in from the CJI, where they are observing that there should be a rather transparent scheme so that every party can have a level playing field and there should be less opacity, especially to favor those in power.